Today I have been asked to talk about the Writ of Mandamus. The request has been made by my good friend Mr. Basil Fernando, who is from the Asian Human Rights Commission. He is based in Hong Kong. The Writ of Mandamus and how it can help people, the general public. What does it do? The Writ of Mandamus, if I may speak about all writs, so there are writs of certiorari, mandamus, habeas corpus, Quo-Warranto and so on. These are all remedies developed by the English judges for several centuries in England. And the British have brought these remedies to our country, and now they are embedded in our constitution as well. They are very important remedies. They are really meant for the people of the country to get justice against mostly, not exclusively, but mostly administrative injustices. So, to talk about the writs, of course, I am only going to talk about mandamus today, now at this time. And mandamus, as the word says, mandamus is a Latin word which says do it, mandamus, mandate. It gives an order to do something, command. Shall we put it that way? Command. So, mandamus means the court orders, commands someone to do something. Now, what is it that the court can do? What is the order the court can do? Now, mandamus is used by courts to command an administrative officer to do his duty under the law. Now, when I say under the law, it must be under statute law, maybe Act of Parliament or delegated legislation made rules and regulations and so on, or bylaws under Act of Parliament. So, it is only statutory duties that can be enforced by mandamus. That is a very important point to be remembered when talking about mandamus. Now, mandamus, for instance, cannot be used to enforce private rights. I will give an example. For instance, you have a voluntary association, you have a constitution, and the constitution says, for instance, that the secretary of the association shall call up meetings at various stages, maybe an annual general meeting or a monthly meeting and so on. So, suppose he does not do that, you can't get mandamus to compel him to do it. No doubt it is his duty under the constitution of your association to do it, but mandamus is not the remedy. You may have to go to a district court and get an order for him to do it, but not mandamus. Why? Because mandamus compels only statutory duties to be performed, that is under Act of Parliament or under law made by someone in terms of an Act of Parliament, made by a minister or somebody else. So, that is one restriction on the law of writ of mandamus. It is only public duties that can be enforced. So, private duties cannot be enforced. That is the first point I wish to make. Then, how are public duties enforced? Now, for instance, to take an example, a certain officer has a duty to hold an inquiry. He does not do it. The duty is cast on him by statute, maybe in Act of Parliament or by delegated legislation like rules and regulations. Then you can bring an proceeding in a court of law asking for writ of mandamus, and he will be compelled by the court, commanded by the court to carry out his statutory duty. Now, in those circumstances, it is also very important to remember, now we expect to be benefited by the duty being carried out by the public officer. For instance, if building is being constructed without prior approval from the authorities, and it is going to hurt us in the sense that maybe that it might cause damage to my property, or it is obstructing my user of my property and so on and so forth, or it is in a dangerous position, it is dangerously constructed, it might even fall down on my property and cause damage to me, then the law says that that building should be pulled down because it is unauthorized building, and the duty is cast, shall I say, on the Urban Development Authority or delegated by the authority to the local authority like the Municipal Council or the Urban Council or the Pradeshia Sabha and so on. So, in those circumstances, That is a very good example of a person trying to use the writ of mandamus to have some statutory duty performed. And once the court is informed of what has happened and the authorities are not carrying out their duty to take steps to pull down that building which is unauthorized, then you can go to court and ask for writ of mandamus, compelling them or commanding the chairman or whoever is vested with that power to use his power to file proceedings in court if necessary for the purpose of bringing down that unauthorized building, because it is a dangerous situation for you. Of course, when you ask for a writ of mandamus, the officer might come back and say, look, I have done my duty, I have carried out my duty. But then the question arises for you to say, check whether he has actually carried out his duty or not. He may have done something which might amount what in his view to carrying out the duty, but that is not enough. It must be carrying out of a duty as required by law. In other words, it must be validly done. The duty should have been carried out validly, not invalidly. If a duty is carried out invalidly, the court will compel him to carry out that duty validly. That is a very important distinction. For instance, there was a case where the Municipal Council of Colombo, there was a resolution moved in the Municipal Council of Colombo by a member of the opposition in the council. I am talking about maybe about 50-60 years ago. And the mayor has the power to allow or disallow resolutions of members to be moved at any monthly meeting of the council. Now, in this instance, the mayor of Colombo ruled out certain resolutions proposed to be placed on the agenda of the monthly meeting by certain members of the opposition. Then those members of the opposition went to court complaining, look, he has not carried out his duty of placing the resolution on the agenda. He said, no, I have carried, the mayor said, I have carried out my duty. I have exercised my discretion and I have cancelled, I have refused to put them onto the agenda of the meeting. But the court held, no, you have no such discretion, therefore you have not carried out your duty of putting the resolution of the opposition members on the agenda for discussion at the relevant monthly meeting. And they ordered, they commanded, that is what mandamus is for, commanded the mayor of Colombo at that time to put those resolutions on the very next monthly meeting of the council for discussion by the members. This is one example. So, it is very important to realize that merely because somebody might say, well, I have done my duty, that is not the end of the story. You have to say whether he has done it validly or invalidly. And therefore, it is very important that the duty should be carried out. It should be a statutory duty, and if he has failed to carry it out validly, then the court will order him to carry it out validly. Now, as I said, private duties of course cannot be carried out by commanding by mandamus. And another question that might arise in applying for mandamus is whether in what terms the parliament or the subsidiary legislation has conferred the duty. Now, sometimes the word used is such and such an officer may do such and such a thing, or it may be such and such an officer shall do something. So, the English words may and shall have their definite meanings. Namely, may means it is a discretion for him, but shall means he is obliged. It is, there is no doubt about it. He has to do what he is ordered to do, shall. But that is not the end of the story. Now, sometimes the word may is also interpreted by the law courts to mean shall, because it is in the context of the statute that one has to interpret words. The word may sometimes is interpreted as shall. So, in that case, if he has not done his duty, he can't say, well, I have a discretion, I use my discretion not to do it, he can't say that. He has to do it because the word may there really, according to the court's interpretation of it, means shall. It is for the general public's benefit, because he just can't say I have done it or I am not going to do it, because the courts interpret it in that way. That is another very important example. And I must also say that the duty to be enforced by the officer concerned must be a duty owed to the person who is complaining of it. Now normally the person who is prejudiced or disadvantaged by the failure of the relevant authority or the officer to carry out the public duty that he owes is someone disadvantaged. So it is that person who will go to court and complain to the judge, please get him to do this, because it is going to be disadvantageous if he does not do it. So there he is called the petitioner, in the court he is called a petitioner, and the officer is called the respondent. And the court in which you can ask for mandamus, that is also very important from the point of view of the public. Now the Court of Appeal has for a long time been exercising the power to issue writs of mandamus under Article 140 of the Constitution. Article 140 empowers the Court of Appeal to issue writs of mandamus and other types of writs like certiorari, Quo-Warranto and so on. And also Article 141 of the Constitution empowers the Court of Appeal to issue writs of habeas corpus, which is a very important writ in English public law, because that is the writ that will protect your personal liberty. Well, today I am talking about only mandamus, and mandamus is therefore very important remedy if you are disadvantaged by the fact that you are not, then the officer is not carrying out or the authority is not carrying out its public duty. So the general public is very much helped by this remedy in law, that is writ of mandamus, because when something has not been done, it is to a disadvantage and it is to the advantage of the public that it should be done, then the court will order it to be done, command it to be done. That is why it is called writ of mandamus. Now the other point I had wished to talk about is, where can you get the writ of mandamus? Well, basically it is the Court of Appeal in Colombo. Whatever the reason, whatever the basis, whatever the law which is giving the power to do it and so on and so forth, the Court of Appeal has undoubted jurisdiction to issue writ of mandamus under Article 140 of the Constitution. Apart from that, now the 13th Amendment to the Constitution in 1987 established 9 high courts, that is 1 high court in each province, administrative. For instance, the Western Province, the High Court of the Western Province, High Court of the Southern Province, High Court of the Northern Province and so on. Now these high courts also have been given to a limited extent the power to issue writs of mandamus and other writs as well. Now the power of the High Court is restricted, as I said, not as wide as the Court of Appeal's powers. It is restricted because, first of all, the duty to carry out the public duty should have been given either by an act of parliament or by a statute of the provincial council of that particular province. So that is an important restriction, rather you might even not call it a restriction. That is an important point to remember. So when you go to the provincial high court, maybe it is easy for people to go to the provincial high court, for instance far away in Betiklo or in Tisamaharam or far off place from Colombo. They do not need to come to Colombo and retain maybe expensive lawyers and maybe staying here in Colombo for the purpose of getting ready for the case and so on is also costly. So it is a good thing that this power to issue writs of mandamus has been sort of decentralized, if I may put it that way, decentralized to the 9 provincial high courts. And another restriction is that the power which you want exercised should be power to be exercised within that particular province of the provincial council to which provincial high court you are going. For instance, if it is say Kandy, the power had to be exercised in Kandy, for instance somebody is putting out an unauthorized building next to my building, and I ask the urban development authority, please consider that this is going to be a dangerous thing to me. It might fall on my building and cause me damage. If they do not do it, you can go to the to the High Court of Kandy. It is under the statute Act of Parliament that the UDA, that is the Urban Development Authority, has been established, and you can ask the court. But there are other restrictions. It is in Kandy. Therefore, the High Court of Kandy will have jurisdiction. Provincial High Court of Kandy, Kandian province of Kandy, the province of Kandy, central province. Or of course, you can come to Colombo. Colombo always has jurisdiction, whichever the province, whatever anything may be. In Colombo, the Court of Appeal has jurisdiction. Then and so on. So that is the setup. Sometimes writs, including mandamus, could be obtained not by the Court of Appeal, but by the Supreme Court. That is because of special legislation. For example, the Election Commission, I think this matter cropped up recently also because so many people applied to the Election Commission to have their political party registered as a registered political party. Then they get certain exemptions and so on, benefits when they contest an election. But several of these applications were turned down, and they have had to go to court and say, no, it is, tell the court, it is the duty of the Election Commission to accept my application for recognition as a political party, but they have not done it. It is wrong, or they have refused it. They have refused it, that is wrong. They must be compelled. So, the statute, the law says that against the Election Commission, you have to go to the Supreme Court for a writ of mandamus. Similarly, there are other institutions also, for instance, the UDA. There also you have to go to the Court of Appeal, also the Supreme Court instead of the Court of Appeal. That is because of special legislation. So, those are instances in which not the Court of Appeal, not the Provincial High Court, but only the Supreme Court has jurisdiction to issue writs of mandamus and other writs as well. Then talking of writs, apart from mandamus, there are so many, 3 or 4 other writs as well, and there are certain restrictions on the issue of writs, including mandamus. That is the next matter that I wish to talk about. Now, we should talk to you about certain restrictions that may be placed by law on the issue of writs, including writ of mandamus. I wish to refer to a particular form of statutory provision which is very frequently found in various statutes in our country and also in other countries as well. Namely, where power is given to make some decision like order or some other decision, and thereafter the statute goes on to say that the decision shall not be called in question in any court. The decision shall not be called in question. Those are the key words. Then how does the court tackle that type of situation? Now, the interpretation of those words, the order or command or whatever shall not be called in question in any court, those words are to be interpreted in the way that section 22 of the interpretation ordinance has set out. Namely, that it says that such words will deprive courts of jurisdiction to call in question something that the order has been done, that the decision of the officer concerned under statutory duty has been done. But here the law says where order is made under this section, it shall not be called in question in any court. Now, the law in all Commonwealth countries interpret in a particular way, namely that it has been validly done in the exercise of the power conferred by the statute. If it is not validly done under the powers exercised by the powers conferred by the statute, then the words shall not be called in question does not apply, right. But to counteract that interpretation of the courts, the Parliament enacted in 1972 section 22 of the interpretation ordinance, which says that where power is exercised and it provides that such exercise of power shall not be called in question in any court, then whether the power is exercised validly or invalidly, whether it is actually or purportedly exercised, it shall not be called in question in any court except in two ways. Firstly, the proviso 1 to section 22 of the interpretation ordinance, which says that where the order, decision, etc. is ex facie not within the power conferred. So the officer has gone completely outside the power that has been given to him. Then such decision, order, determination, etc. can be called in question. That is the first type of situation. The second type of situation is that where the decision had to be given by following rules of natural justice. I will explain that in a minute. And rules of natural justice not being followed, in that case also, in spite of the words shall not be called in question in any court, the court can call in question by writ of mandamus and say, you have not done your duty, we are now ordering you to do your duty. Now the rules of natural justice, there are two rules of natural justice. First of all, no one can be condemned or deprived of his property or personal liberty except after hearing him. No one can be condemned unheard. Even if the statute conferring the power to give a decision does not say that the person to be affected must be heard before order is made against him, still the law requires that the officer concerned must hear him before the order is made. That is what is called natural justice. To take an example from the Bible, when Adam and Eve sinned against God, God did not condemn Adam and Eve immediately. God called Adam and said, what have you got to say for yourself? Then only they were ordered to live by the sweat of their brow, and they became people who did not enjoy anymore the privileges of what God had given them originally. I am just an example. So following that, one can say that if there is a statute which will adversely affect, shall be somebody, X shall we say, then X has to be heard. Why such an order should not be passed against him? Otherwise the order is not valid. So the words shall not be called in question in any court, notwithstanding the court can call in question and ask the order to be held to be invalid and the exercise of power to be done again on second time after hearing the party to be affected. That is an important point. Now when I say that we can go to court and ask for a writ, and I said that a person against whom an order is to be made has to be heard before that order is made against him. That is the principle of natural justice which all civilized countries follow. No one can be heard whether in respect of his property or his personal liberty without being heard. That is why there are the courts to try people for various offences and courts to hear civil disputes as to who is in the right and who is in the wrong. Because without hearing a party, it is not correct in our law or in most countries to condemn a person without giving him a chance of being heard. What he has got to say. Now, the persons to be heard, of course, is the person against whom the possibility of an order being made. That, of course, is the person against whom somebody complains and say, please issue an order because he is putting up some building which might collapse on my building. I take the same example. Now, the person who is putting up the building has to be heard, because if the order is to be made that his building should be pulled down by the authorities, by the bureaucracy, then he will be at a disadvantage because it is his house, he has partly built it. Therefore, he has to be heard. Then the person complaining, what is your complaint? The court must know what exactly, how do you say that he is putting up a building like that is going to fall on your head, fall on your building? He must be heard. And thirdly, the person who exercises power, whom you want the court to command to pull down the building, he must be heard and said, he must be heard, have you authorized this building? Have you considered the pros and cons of authorizing a building like this? He must be heard. And therefore, all three parties have to be heard before the court makes a final decision on whether to issue the writ of mandamus that has been applied for or not. Now, in conclusion, I wish to say that I can summarize what I have been talking to you about. First of all, the importance of the writ of mandamus for the general public. Namely, if a member of the general public feels that a statutory body or an officer, for instance, does not do his duty and that thereby he is prejudiced, then he can go to court and ask the court to issue writ of mandamus to compel or command that particular officer or the authority or the bureaucrat to exercise his power and carry out his public duty. But it must be a public duty, it can't be a private duty. For instance, some people might think, well, we have an association, say a football association or some other benefit association or something, and they have their constitution, and the constitution imposes certain duties on certain office bearers. Like secretary has to call up a meeting every month or annual general meeting and so on and so forth. Or the treasurer has to give up accounts. That's very important in a voluntary association. Now, if he does not do that, mandamus is not the remedy, because there is no statutory basis for that duty. It's a contractual basis, in the sense that people have joined that association of their free will, and they have made a constitution for themselves, and the constitution says, well, he shall do this and he shall do that. If the treasury is not giving, or the auditor is not doing his job, if the treasury is not giving up accounts, showing accounts and so on, that is not a public duty, that cannot be enforced by mandamus. So, therefore, you have to distinguish between a public duty and a private duty. That is very important. Then next, when you go to court and say, well, it has not been done, first of all the question arises, does that officer have the power to do it? That is a matter of interpretation of the relevant statutory provision. If he does have the power, he might then say, well, I have done my duty, I have done it in this way, that's all. Well, the complainant can say, well, you have perpetrated or you have tried to do your duty, but that is not the proper way of doing it. What you have done is not valid. Therefore, please carry out your duty in a valid way. So, that is another important question. As I said, for instance, in the Municipal Council of Colombo, there was a problem like that, and the mayor used to say, well, I have a discretion in the matter, I have refused the resolutions of the members of the opposition, but the court said, no, you don't have a discretion in the matter, because you have the duty, you must place it on the agenda of the next meeting of the council. Second, the next point, the word may also can come into the picture in this way. The law may say, in such and such circumstances, the officer may do this. Now, the word may has to be interpreted whether it shall or discretionary. That depends on what was the intention of Parliament. Was it to benefit certain persons? In a situation, a particular situation, the officer has the duty to do it, because it has to benefit certain persons. That was the intention of Parliament. Then the word may will be interpreted as the word duty, as a word shall, as the word shall, as normally understood in the English language, may and duty and shall. Then the question arises, where can you go for a writ of mandamus? What are the courts that can give writ of mandamus? It is not the lower courts, like for instance the primary court or the district court or the magistrates court and so on. Writs are available basically from the Court of Appeal in Colombo. It is sitting only in Colombo under Article 140. So, wherever you may be in Jaffna, Batticaloa, Galle or Hambantota, you have to come to Colombo and retain lawyers and file your case and get the writ of mandamus. But in 1987, under the 13th Amendment to the Constitution, this power of granting writs including mandamus was decentralized. In that year, 9 provincial high courts were established, one for each province. Province of Jaffna, province of High Court of the Western Province High Court of the Sabaragamuwa Province, and so on and so forth. So, those high courts have also been given limited powers to issue writs. And the last point I wish to mention is that there could be restrictions on the granting of writs. The power to question orders of officers, of the bureaucrats. Parliament may say, we hereby authorize him to do certain things in such situations, and proceed to say, Parliament might say, and what his order shall not be called in question in any court. They are the courts interpreted, well, if you have done not your duty, it is not an order given under the statute. Therefore, you please carry out your duty. That is the way the courts interpret it. That is to say, the law the intents that he must do his duty and not pretend to do his duty or do something which he calls it carrying out the duty, but it is not so. Therefore, it is very important that the courts will look into, they will not go by the labels and orders and news and names you give to various things. They go into the material, what is the bottom of it, and find out what has actually gone on. So, that is the writ of mandamus, and all other writs are for that purpose. It is a very important remedy which were conceived of and developed by the English courts. I must mention that the writs were developed, as I said, by the judges down the centuries in England, and they were very important for protection of people against the bureaucrats. Now, the British, as you know, colonized various countries in various continents, and they took with them their laws, and the British took with them these remedies of the writs, including the writ of mandamus. And it is a global remedy, in fact, in all English speaking countries, namely in all Commonwealth countries and former Commonwealth countries, English speaking, the writs are there to protect people against the government and its bureaucrats. For instance, in Southeast Asia, not only in Sri Lanka, but in India and Pakistan, in Nepal, have the writs all modelled on the English law, like in Sri Lanka. Then when you go to Africa, all African countries that were British colonies, and now they have gained their independence, including South Africa, Swaziland, Namibia, all these countries have their writs, including writ of mandamus. And the other original colonies of the British, namely Canada, Canada, Australia, New Zealand, they all have the writs. The operation of the writs is very similar in all these countries, and the legal literature from one country enriches the legal literature of the other country. For instance, still we learn a lot about the writs and how they can be adapted to suit developing situations by using English textbooks written by various important authors on administrative law in England, and similarly in India, Pakistan and Sri Lanka as well, and Australia, New Zealand and Canada. So, this is a developing area of the law to protect the people, to protect the general public from wrongdoing or injustices caused to them by the bureaucrats, by the government and its officers. Thank you.